minutes to log. The meeting is also being recorded. We're going to give folks a couple minutes to log in, so we'll be back in just a second. The webinar, everybody. We're going to give folks another minute or so to log in, and then we'll get started. Going to get started. So this is Andy Cleek from McTac, and we're all here today for the BHCC Clinical Integration Learning Collaborative webinar. Go through a little couple of housekeeping and logistics items before we dive in. But I have one announcement to make. We have a little bit of an unusual situation today. The primary mission of our goal or topic for the webinar today is to have Mark Boss from OASIS talk through 42 CR and its implications for BHCCs. He got called away at the very, very last minute to a call with the governor's office, which obviously he had to take. He's going to be a little late for us today. So I'm going to take a minute and walk through the logistics and a couple announcements. And then I'm going to offer Lynn and Ileana if they have anything else that they would like, any other announcements they'd like to make. And then we may ask folks to put themselves on or to just kind of hang out for a couple minutes. Until Mark is able to get back from his call with the governor's office. We're hoping that he'll be back on the line by around 12:15 or so. I would apologize in advance. This was obviously a very, very last minute thing, and so we're trying to do the best we can. But there are some of those calls we all know that you have to take, and so he is going to be doing that. He's doing that, and then he should be back very shortly. So I'm just asking folks to just kind of bear with us today because the presentation is very important, and we don't want to shortchange it. But we also understand that he had to take that phone call. So that being said, I'm going to dive into the usual logistics, and then to also make a couple of announcements as well. As all our webinars, this one is being recorded. And we will share the link when it's over, along with the slides. When we get to Mark's presentation, we will unmute participants to share their feedback. As always, folks should always keep yourselves on mute when we unmute you, unless you're talking, because otherwise we hear what kinds of construction is going on outside your office, or what is passing you on the road if you're in the car. So just want to remind that when we do unmute you, to please mute your own phones on your own side, so that you don't end up sharing what's going on in your office with the rest of us. Okay, so that's the basic thing. Other thing is, as we all know, because the date has passed, we did postpone the BHCC live event. It was going to take place in July, and we've postponed that till the end of October. We are right now looking at October 29th. That date's pretty firm, but should firm up officially very, very soon. And obviously we will work with all of you and get an announcement out. The event will take place in Albany, and we'll get an announcement out, save the date out as soon as humanly possible, as soon as it's formal, official. And then the other announcement and just reminder that I have is we do have 2 more of these BHCC Learning Collaborative webinars coming up on August 23rd, and again on September 20th. And we sent out a survey that we're asking to get back by the 3rd, which I believe is next Friday, that we'd really like to get feedback from folks about, really what they want the content of these webinars to be and what would be most helpful to them. And so, we will, I'm sure we'll send some kind of reminder before it's due, but just also want to encourage folks to fill out, because really the goal of these webinars is to provide information that's helpful to folks, and so we want to get that out to people as well. So just for folks who joined late, we're going to take a little bit of a holding pattern here for a moment today, because Mark Boss from OSS, who's joining us to give the presentation on 42 CFR, got called out like a minute ago to go take a call to the governor's office, and so he anticipates that will wrap up relatively quickly. But he did have to take that call, unfortunately. So we're gonna after we kind of get through announcements, we'll take a brief pause, hopefully, for him to wrap up his call, and then he will be back and walk us through 42 CFR. So at this point, I ask Lynn and or Ileana if they have anything else they would like to add before we kind of take our brief pause, and also highlight if they do have anything they want to add, to take themselves off mute before they do so.
And I think I just heard Lynn join in as well. Is that correct?
I think now, yes, she just got off mute.
Hi, this is Ileana. Hi, everyone. Nope, just to thank everybody for their patience for today, and that just to signal, we have been meeting with the BHCCs. We've met with some of them. We continue to meet with some more throughout the rest of the summer. We're finding the time to chat with the BHCCs, how things are going with them, really informative. So that's great. And as far as the survey on future learning collaboratives, as Andy signaled, please let us know what's of interest to you. Lynn, anything else you want to add?
No, you guys got it covered. Thank you.
What we're going to do is we're going to take a brief pause here and wait for Mark to join us. And when he does, we'll dive into his presentation on 42 CFR. So feel free to take this. This is the only time on a webinar I will ever say that now is the time to answer your email. So that many people do answer their email during web-based trainings, but now you have full and free permission to answer your email for the next, hopefully, 5 minutes or so. And as soon as Mark gets back, we will dive into his presentation. Thanks, everybody, for joining, and also thanks in advance for your patience. still waiting for Mark, so just your ongoing patience, and as soon as Mark gets back online, we'll turn it over to him to talk about 42 CFR. Thanks for your patience. Again, from McTack. We're still in this holding pattern, so I just want to let folks know that we were still here, and hopefully we'll be able to get started in just a minute.
Everyone, this is Mark Boss.
Welcome back.
I apologize for the delay.
Oh, not a problem at all.
All right. So, you ready to proceed, or is there?
We are completely ready to proceed. No, we're ready to proceed. Do you have slides, or are you just going to talk?
Talk.
Fantastic.
Pages layout. Some rough outline about part 2, and then I'm open for questions that anybody might have.
Perfect. So what we'll do is we're going to keep people on mute while you do your presentation, and when you're done, we'll unmute the line and people can ask questions. Okay?
That's great. That's great.
And also, people can feel free to chat in questions along the way, and if they come in on the chat box, I'll read them out when you're done.
Wonderful. Wonderful. So again, everyone, I apologize for the delay. Basically, right, what we're trying to decide here is the best way for the BHCCs to be able to access information that's protected by Part 2. And there are a few exceptions to the Part 2 rule that allow access, and I'm just going to touch on a few of those, and then I'm going to focus in on the consent, because probably the consent is the primary and best way to go about obtaining permission to access protected information. So a couple of inquiries that have come to me, which are typical of any kind of initiative where people start thinking about the possibility of accessing Part 2 information before they have a consent, are the Qualified Service Organization Agreement, which I think everybody's familiar with. They're similar to a business associate agreement. There's the audit and evaluation exception, the research exception, and then there's the consent. Service organizations agreements have gotten a lot of interest because people recognize that SAMHSA has come out and said that QAs can be utilized for Part 2 providers to have information made available to exchanges. The thing about service organization agreements that everybody has to keep in mind is these are specialized business associate agreements, but they're intended only for 2 parties. They're only 2-party agreements. So it's between an SUD provider, Part 2 provider, and a service organization that's providing some benefit to that provider. Any information that flows between those two without or it can flow without the client's consent, but it can flow between those two parties. Once the qualified service organization obtains that information from the program, the qualified entity cannot further redisclose it unless it can do under one of the other exceptions of the rule, which is the consent of the client. And SAMHSA has come out and said that, yes, programs, Part 2 programs, can upload protected information to health exchange systems on the condition that those exchange systems don't allow access until the client's consent has been obtained. The audit and evaluation exception. Again, this is a specialized exception that allows entities that are generally or oversight agencies to go in and at a program's operations, and in doing so, they have the ability to see and sometimes obtain client information. The nuance with this is that any information obtained by the auditing entity that would reveal the client's identity can only be disclosed back to the program. So it doesn't really provide a vehicle for an entity to come in, audit a program, and then share that information with anybody other than the originating program. The research exception was actually, it appears with the revised regs that it's been expanded, but in actuality, really, what seems to have occurred is just that SAMHSA has explained the situation a little bit better. Part 2 information has always been available through research, through the research exception, but the revised regs have articulated is that now anybody who's going through the research exception route needs to follow and comply with HIPAA, which in fact been the case all along. It just wasn't explicitly stated. So research is a way that an entity can come in, and again, it can obtain client identifying information. But what research has concluded, anything that's going to be disseminated, it cannot identify clients. It can only be information that's disseminated in the aggregate. So then that is the vehicle to obtain client information where the purpose, the intent is to pool that information and share it with other entities. And there's the one other exception. 2 only covers information that identifies an individual that has been, is currently, or has been referred to SUD treatment. So if information that doesn't necessarily identify someone as having or receiving treatment, the otherwise unprotected information can be disclosed, just like it is with any other HIPAA data. And of course, we get to the consent, which is what we've been trying to work on. The consent is the ideal tool because it allows the info to be disclosed from the particular client to a number of recipients for a number of purposes, as long as those recipients and purposes are identified in the consent. So those are the primary exceptions I think that would be considered for this kind of endeavor. And I just want to start or end it there and see what questions that I can work through with anybody that might have them.
Okay. So if we could unmute the and then if folks have a question, they can feel free to ask their question. I would ask that everybody put their phone on mute unless they're explicitly asking a question. And you can do that through your normal phone, or you can do that through the webinar. So if anybody has asked a question, please go ahead. you know, this is a great opportunity to ask a question about 42 CFR. So I would, if you have one, now is definitely the time to ask that question.
This is Josh Rubin from the CBHS. And you had indicated, and thank you, the presentation was really helpful. You had indicated a mechanism for one-to-one data sharing. I'm just wondering, in the context of a larger group, an IPA, for example, what would be the method, what would be the acceptable methodology for broader sharing of information within the confines of the IPA, or is this just going to have to be dozens of one-to-one data agreements?
I don't think, from a practical perspective, that you know, when the ultimate goal is to be able to obtain the information and legitimately redisclose it to particular participants in a group, a QSOA is not the effective way to go about that. Consent is the way to go about that. And, you know, I think if you can identify who needs to receive it, you can articulate that in consent and achieve that goal.
But I just want to make sure I'm clear. That would be a specific consent with respect to the specific data covered by 42 CFR.
It's a consent that covers the data related to Part 2. If the disclosing entity has the way to segregate out SUD data, you don't need to have a Part 2 consent to or access data that would otherwise be covered by HIPAA. It's a specific consent from the aspect that the IPA and potentially the participants would have to be identified in the consent. And the purpose for the IPA was accessing the information.
Got it. Thank you. That's really helpful.
So just to clarify, so a consent that highlighted that these 10 agencies are part of this IPA, and that the participant is giving consent to release certain CFR covered data in these circumstances for these particular reasons, and that would cover it in this time frame.
That's correct.
Next.
This is Sharesky at Catholic Family Center. How are you? To just clarify thing that I say and just sort of run the scenario. So if you are looking for some de-identified aggregated data that would be coming out of a data platform of some kind, the organization had a QSOA with that data platform, does allow then for de-identified aggregated data to be shared amongst the providers then?
If it's true de-identified aggregate data, you really wouldn't need a QSOA. You could get away with a business associate agreement. Because QSOA is only relative to identifying SU data. And if it's, again, string, that it's truly de-identified aggregate data, it certainly can be shared.
So, just to sort of run it around one more time then, if the information that's being uploaded, that data analytics area, unified, the QSOA would be relevant, and they distribute it back out in de-identified capacity? They get a feed with some specific data in it from the BHCC partners. They could share de-identified data afterwards.
So are you saying that there will be an entity or a component of an entity that would collect identifying data from various sources, de-identify it, and then share aggregate data?
Yeah, that's exactly right.
Well, that probably is permissible. I mean, that essentially sounds like the research exception, though this may not be for bona fide research purposes, but I think that, I mean, QSOA, yeah, captures the fact that the service that's going to be provided is going to identify the data and goes to any other party. That may be permissible.
Okay, thank you.
This is Dave Friedmutter. I have a question. If an IPA is getting information from psyches, how do we? I assume the identified data we get through psyches is the BAAs that they put in place are sufficient. But if we want protected health information, and we're using a consent format to get consent, how do we communicate? Maybe this is a psyches, this is a OMH question, but is there a how do we communicate sense to a database like psyches to get when we get a broad-based protect health and understand list of people who need having problems with services?
Okay, it sounds like somebody put their phone on hold, which is, there we go.
So if I think if I can try to re-articulate, are you asking, you right? A consent, you need a consent from a particular individual to allow psyches to disclose protected information.
Right, I'm talking about so you have an IPA view now. Many of the BHCC grantees are negotiate or have contracted for BHCC views, which So I guess what I'm trying to understand is how would, when we're talking about having 10 or 15 or 20 providers in a network, and each of them may have gotten some consents, but not all the consents of people who are receiving SUD services, how logistically, are you aware of like methodologies, how logistically do you communicate that information so that you can get protected health information?
Communicate it to psyches to indicate that you've got consent? Yes. I'm going to have to defer to the psyches team on that one.
Hi, can you hear me? Okay, this is Molly from Psyche's team. So in Psyche's, in order to indicate consent, there's a way that you go in and you just say, for this client, we have consent. We've been working with Mark and others in OMH's counsel's office to create a revised consent form that would allow you to say, this provider, whoever may have gotten it, and the BHCC network, so that the consent would say that. And then you indicate that you have that consent, the application knows and will make data available to you.
Molly, you'd have to keep the consent on file and subject to audit, I assume.
Like any other consent that you would obtain when you work with a client, it should go in your charts, or it should go wherever you put your consents.
But he isn't actually holding the consent.
It's holding your attestation, but it's not holding the consent itself. It's something that we're looking at, that you could kind of be signature from the client, and then it would be stored in the application itself. But right now, it's really whatever you have the client sign the paper, and however you store all your paper consents is how you store it.
Next question. All right. If there are any more questions, now would be the time to ask them. if there aren't any more questions, I want to thank Mark for taking the day to join and also listening to his call and then running back to join us and really provide some informative information about 42 CFR and how to work through that process. If there are additional questions, feel free to send them into the mctech.info email or to either OMH or I guess OHS in this case directly, but you can also send them in our email and we'll pass them along, aggregate them and pass them along. Mark, are there any additional things that you want to make sure that we'll talk about before we wrap up today?
Yeah, slight little things that I was involved in a conversation earlier in the week, and I wanted to point out something. May or may not be helpful to everyone, but with this regs, has come out with this term lawful holder. Recognize any individual or entity who's legitimately come into protected SUD data. And the question was put to me earlier in the week, well, if I'm a lawful holder and X is a lawful holder, we're both lawful holders, can't we exchange information? And after one of the options, the answer is no. Just an individual, an entity as a lawful holder, that doesn't give you any additional rights to protected information that you don't currently hold. And so anybody thinking of themselves as a lawful holder basically has to think of themselves as the original program, and they're trained by the same rules as the program when it comes to further redisclosure. So I was interested that that comment was brought up, and I just wanted to raise it here so people can think about that. So
okay, thank you.
Again, I'm available. Anybody wants to send me emails or call me, I'm willing to do that. It's I don't know if my email's up there, but it's mark.boss@oasis.ny.gov. Yeah, just give you my phone number too. It's 518-5212.
So folks can email or call Mark directly, and then also if they need to or lose the email or whatever, feel free to send it to mctech.info, and we'll be glad to pass that along as well. Before we wrap up, Anna or Lynn, anything you guys want to add before we close up the call today?
I don't have anything.
Nope, very much for being here.
So thanks, everybody. Mark, again, thank you for joining today, and everyone on the line, thank you for joining today, and also thank you for your patience while we wait for Mark to wrap up his other meeting. All right, so thanks, everybody. We're almost to a weekend, so enjoy a weekend, enjoy the summer as it continues to roll out. Thanks, everybody. Bye-bye.
Thank you. Take care. Bye-bye.